Back to the news now. An appeals court overturned the sexual assault conviction of former Baylor athlete Sam Uklwuachu. As Dennis Turner shows us, the issue is cell phone tracking data, how and whether prosecutors can use it.
Andre Perdon may never get lost because his cell phone always knows where he is.
It's interesting how quickly they keep track of all the things that we're doing now. But like I said, it's a necessary evil.
His phone company tracks his every move to make sure he gets his data and his phone calls. So it's no wonder prosecutors love to get warrants for cell phone data that tracks defendants and even witnesses. McLennan County prosecutors used that very data to convict former Baylor football player Sam Uklwuachu in a 2015 rape trial. Now, the 10th Texas Court of Appeals has called out prosecutors for referring to cell tower location information during trial without actually entering the paperwork into evidence, all to suggest a witness lied about where he was the night of the crime. Legal scholars call that troubling.
Think about it from the jury's perspective. If you're sitting there and you're hearing the prosecutors and they're referring to these call logs and they're making it seem like these call logs are very important, but you can't actually see those call logs, I mean, it's natural that that would influence your thinking and you might come to the wrong conclusion.
The appeals court said as much in its ruling invalidating Sam Uklwuachu's conviction. What's the appeals court's remedy to the situation? The 3 judges on the panel ordered a new trial. Again, right here, where it all began. But next time, it's likely prosecutors will either have to enter the cell phone records as evidence a jury can see, feel, and examine, or do without it altogether. Uklwuachu's attorney calls it an important protection of citizens' rights.
We're not going to convict people based upon unadmitted evidence, so I think it's a protection for all of us.
Andre Perdon likes the sound of that.
If the decision's going to be up to them, they should see all the information and not just some of it. You know, it has to be fair, right?
Because he doesn't believe a court should ever convict anybody based on hearsay-like evidence not entered in the record. In Woodway, Dennis Turner, Central Texas News Now.
Now, speaking for the McLennan County District Attorney, Tom Needham of the office's criminal division said, quote, "The evidence was correctly and properly used during trial. The decision will be appealed," end quote. Now, stick around. We'll be right back.